I'm not threatening you. Say one more word and that's 30 days. 30 days.
The moment this hearing begins, you can already feel the tension in Judge Simpson's courtroom building like a pressure cooker. Today's docket is stacked with defendants pushing limits, testing boundaries, and in some cases outright defying the court's authority. And right from the first second, the judge isn't wasting a breath. He lays down the law with a warning so sharp it slices through the room. One more word equals 30 days. That sets the tone for what's about to become one of the most chaotic, revealing, and emotionally charged court sessions you'll witness. In this video, we're walking into a lineup of cases that showcase everything from refusals to appear, competency battles, wild jail phone violations, defendants representing themselves without understanding basic procedure, and bond decisions that escalate from strict to catastrophic in seconds. And yes, the drama is real, the stakes are high, and Judge Simpson, he's not in the mood for games. As you follow each defendant through this maze of legal consequences, watch how the judge navigates manipulation attempts, conflicting excuses, bizarre explanations, and raw emotional reactions. You're going to see defendants contradict themselves, argue over identity, claim their dog chewed off a tether, and even insist that non-alcoholic wine got them buzzed. This courtroom isn't just handling cases, it's teaching lessons, handing out reality checks, and exposing the difference between controlling the narrative and facing the truth.
Court does call the case People versus Radiance Evans.
Good morning. This case is proving to be challenging already, and Ms. Evans will not meet with me. Although in the conversations that I have been able to have with her, she has affirmed her innocence in all charges against her, and she's appeared twice for her PPO violation before Judge Slay. It is my understanding from what I have been able to speak with her that she would like to schedule this for preliminary examination and proceed in all things available to her. I don't know that if I refer to her competency that she's going to be found not competent based on what I can ascertain of her understanding of all the proceedings, who I am, what she wants to do in terms of her defense. So I would ask that the court set this for a preliminary examination. And then I'm curious to see how the court will respond to my request.
My understanding is she does not wish to come to this hearing. So I'm not going to set it for a further proceeding until she decides she wishes to participate.
Okay.
So I will adjourn this out. Would you like 1 or 2 weeks?
Let's just do 2 weeks.
2 weeks. So I'll adjourn this out June 6, 2024, 9 a.m.
Thank you, Judge.
Thank you. Bond continued. Court does call the case People versus Casey Adkins.
This quick transition shows how efficiently Judge Simpson moves through cases, but also how easily that efficiency gets disrupted. The defendant simply walks away before the judge finishes speaking, prompting a sharp, immediate reaction. In court, leaving before the judge dismisses you isn't just rude, it's disrespecting the authority of the court. And judges do not tolerate that. When the judge warns attorneys that if their clients pull similar moves, he will snatch you up and send you back. He's sending a very real message. Courtroom order is not optional. Judges must maintain control, not just for respect, but for safety and accuracy in the legal process. Here's a viewer question. Do you think defendants who walk out early are confused, careless, or intentionally disrespectful? In court, intent matters, but behavior matters even more. Today, this won't be the last time someone challenges courtroom boundaries.
So she has another PCC before me.
That's my understanding, according.
I'll adjourn this then out 1 week. May 30th, 2024. 9 a.m. Bye.
Thank you, Mr. Knapp.
Really? She just leaves before I'm done?
I think she's got the date. I thought she thought it was done.
And no, go. Just go. Bound continue. Just start walking. Really?
All right, Judge. Thank you.
No, it's okay. Next one of your clients that does that, I'm snatching you up and sending you back. Court calls the case People versus Daniel Gates.
I ask the court to please set this for exam. Your Honor, discovery is late at this time.
Ms. Hughes says to Ron.
Thank you, Your Honor. I downloaded a spreadsheet of defendant's jail calls and sent them to defense counsel, and then I downloaded the relevant jails and sent them to him so he had an opportunity to listen to them. I am requesting that the defendant's jail privileges be revoked. Since his arraignment, the defendant has contacted the victim 13 we actually had another defendant who's present today, we'll hear about him shortly, call the victim in this case and ask her for a different phone number. She provided that different phone number to other defendants that she otherwise doesn't know. And when I searched that different phone number in the jail call system, the only person to have ever called that number is Mr. Gates after that. So I'm requesting that his phone privileges be revoked. And I provided the jail calls to the defense.
I have nothing to add.
Defendant's bond will continue, however, defendant's phone privileges are hereby ordered revoked.
Judge Simpson wastes no time in cutting off Gates's jail phone access, and here's why. When a defendant uses phone privileges to interfere with a victim or another case, it becomes a direct attack on the justice process. Phone access is not a right. It's a controlled privilege. And once a defendant proves they're willing to misuse it, the court must act decisively. What stands out here is how quickly the judge rules. There's no hesitation, no debate. The evidence is clear, the risk is significant, and the judge prioritizes safety over leniency. This shows how courts balance constitutional rights with practical threats. Now ask yourself, if a defendant shows they won't follow restrictions inside jail, what does that say about how they'll behave outside? Judge Simpson clearly sees this as an indicator of risk, not just to the victim, but to the entire legal process. This kind of violation becomes a major factor later in the day, especially as more defendants push boundaries and test the judge's authority.
Great Memorial Day weekend, your staff, Your Honor.
Take care. Court calls the case People versus Rajad. Is it Frashik?
Got it, Judge.
Got it.
Did I?
Did you got it?
I knew it. I knew I had it. I knew I.
Good morning, Your Honor.
Ready, Judge. Tortial officer, assistant public defender on behalf of Mr.
Court does call the case People versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. And we have your competency report back. Have you had an opportunity to review that, sir?
I have.
Pardon?
I have.
All right. Is there any other additional evidence you want to give the court?
Not at this time.
None from the people, Your Honor. We would stipulate to the report authored by Graham Parker dated May 7th, 2024, and ask that the court make its finding based on the.
Based upon a review of that report and the only evidence before the court would find that the defendant is competent to stand trial and that defendant understands the nature and the objects of the proceedings against him and can rationally assist in his defense. And so the defendant is deemed competent. I'd ask the people to prepare an order if you could.
Once Judge Simpson formally rules Jolly competent, the courtroom shifts into procedural clarity. Competency unlocks the next steps: representation choices, preliminary exams, and case scheduling. But when the judge asks whether Jolly still wants to represent himself, the hesitation in Jolly's answers signals uncertainty, a dangerous sign for someone facing charges with potential prison time. Judge Simpson carefully walks him through the charges, the penalties, and the legal obligations he faces. This isn't over-explaining, it's protection. Courts must make sure defendants aren't unknowingly waiving critical rights, and when a defendant elects self-representation, those protections intensify. This moment raises a deeper issue. Is Jolly choosing self-representation because he genuinely believes he can defend himself, or because he misunderstands the complexity of the charges? Judges must determine whether the choice is informed.
Yes, sir.
In this instance. Mr. Jolly, do you still wish to continue to represent yourself, sir, or do you wish to have the assistance of an attorney?
Continue to represent.
And sir, I do also have to advise you that you are before the court on two charges. It's two charges. Two charges of criminal sexual conduct in the 4th degree. You understand that, sir?
I do understand.
And that these are alleged to have occurred on January 27, 2024. You understand that?
I do understand.
And the court also does have to advise you that these are high court misdemeanors They are punishable by up to 2 years incarceration and or $500 fine plus court costs, mandatory HIV and STD testing, and DNA would be taken upon your arrest and should have been taken. You understand that, sir?
I do understand.
All right. So, sir, I will formally ask you, do you still wish to proceed without counsel?
Yes, I do.
All right. What do you wish the court to now set this for, sir?
The last that I was aware of was the preliminary exam that we were doing. I'm trying to move forward as quick as possible, so I'd ask you if that's where we start, that's okay. If we move
You
forward,
wish to set for a preliminary examination?
if that's the furthest along I can get, then yes.
Well, that's the next step.
Okay, then yes. That's
All right. So you want to have a preliminary examination in this matter, or you want to proceed to circuit court? There are a number of options that you would have.
okay. Yeah, if we can proceed right to the circuit court, that would be okay.
Okay. All right. But you understand that there would not be a hearing, the preliminary examination, which the court would attempt to make a finding or would make a finding as to whether or not crimes were committed and you committed them. That if you were to proceed directly to circuit court, that hearing would not take place. You understand that?
Trial. Yes, I understand.
Mr. Jolly.
Yes, I do
Mr.
understand.
Jolly. Mr. Jolly.
Yes, sir.
You've been before me, I don't know how many times, right? Are you sure you don't want somebody to just help you make these decisions and to assist you as an attorney in this case?
Again, I choose to represent myself. I was aware of the help and was thankful for the help the other day. If you recommend that I talk with somebody as I leave here.
Well, I'm not going to recommend you do anything. I'm a little bit concerned because when I ask you questions, I don't think you know what you're doing. I don't think you know what you're doing procedurally. And that causes me a bit of a concern. You want to get to, as I told you the last time you were here, you want to get to a certain point. You're not sure how
Let's go back to the preliminary exam with you.
This section highlights a common misunderstanding defendants have about their rights. Many believe skipping the preliminary exam somehow moves things forward in their favor. But in reality, the prelim is often one of the most important tools for a defendant, especially one representing himself. It allows defendants to hear the evidence, see the witnesses, understand the strength of the case, and preserve testimony for trial. Losing that opportunity weakens the defense significantly. Jolly appears torn. The judge is openly concerned because Jolly seems unaware of the consequences of the choices he's trying to make. This is a major red flag in a self-representation case. The judge isn't trying to block him, he's trying to protect the fairness of the proceedings. What's striking is that the judge pauses to re-explain concepts Jolly should already understand. He recognizes that Jolly is answering without fully processing the implications. Viewers, if a defendant doesn't understand the purpose of a preliminary exam, should self-representation still be allowed? Or does misunderstanding prove they need counsel? This tension sets up one of the biggest themes in this hearing. Defendants fighting for autonomy they aren't prepared to handle.
You want a preliminary examination?
That'll work. Yes, I will.
All right. If you want a preliminary examination, you intend to represent yourself. Is that correct, sir?
Correct.
Do you have all of the discovery, sir?
I filed for it. I'm gonna have to refile now that I'm competent, but I don't, not when I'm in my possession because I was incarcerated.
All the discovery has not been provided. You don't have it.
It was emailed to me, but I'm incarcerated now, so I don't have it now.
So it was emailed to you when you were out?
Correct.
If the people could try to make sure that whatever discovery is, it be provided to the jail so that they can get it to this defendant.
I can print another copy of the report.
Okay.
Not today, the printer in our office is broken, but there was a media notice that was body cam that was given to him in court at one of the last dates.
Okay.
That was on a DVD.
You remember that, sir?
I do remember the disc. Yeah, I didn't, yeah.
Okay.
So he has the disc.
He has the disc. He just
Another copy of
did the paper report, and we'll get that to you. Okay. Would the people have their witnesses available the 4th, or you need more time? All right, preliminary examination in person will be set June 11th, 2024, 9 a.m. That's before me. Bond will continue. Okay. All right. Thank you, Mr. Jolly. Court does call the case of the people versus Bruce Jones. Preliminary examination will be set in person June 4th, 2024.
Bruce Jones' case introduces a recurring theme in this courtroom. Bond violations rooted in defendants ignoring basic rules. Phone restrictions, tether requirements, and no contact orders exist for a reason: to protect victims, ensure appearance in court, and maintain public safety. When defendants disregard these conditions, judges see it as a preview of future behavior. In Jones's case, the immediate shift to scheduling reflects that there may not be major disputes at this moment. But what follows next, the tether tampering and jail calls, reveals deeper issues. When defendants attempt to outmaneuver monitoring systems, it signals an unwillingness to comply with any restrictions. Judges view tether tampering as especially serious because it suggests the defendant is trying to evade accountability. Claims like "my dog chewed it" rarely hold weight, especially when supported by location data and visible cut marks. This moment sets the stage for an even harsher response from Judge Simpson as the facts unfold.
9 a.m. That is before Judge Perry. Bond will continue.
Need to address is
Oh.
tether tampering from the last date. I'll go with the phone privileges first. At the last hearing, I believe it was Ms. Rosso requested that his phone privileges be revoked. The defendant requested a hearing on that. After Your Honor then revoked his phone privileges, when the defendant went back to the jail that very same day after leaving your courtroom at 10:50 a.m., he got on the phone and called the victim and advised the victim that you had revoked his phone privileges, and then instructed the victim to download an app called Text Now. And he said, if they're going to take my phone privileges, I'm going to still call you, but another way. And that was after Your Honor revoked his phone privileges. Since then, as far as I can see, his phone privileges have been revoked. But he did manage to get to the phone and make that call after the last hearing before today. And then we still have the tether tampering, which is where community corrections received the notice that he was cutting his tether. They reached out to him. They asked him to take a picture of his tether to show them that he wasn't cutting it. He refused to do that. And then they see based on his location services that he was then leaving the area that he was in. He was arrested. The tether has a clear cut mark on it, and he told community corrections that his dog was chewing on it. So at this point, I'm requesting that Your Honor continue to deny his bond, which was denied after the tether tampering situation, and I'm asking that Your Honor continue the revocation of phone privileges.
This section reveals how damaging repeated violations can be. The prosecution outlines not just one mistake, but a consistent pattern. Tether tampering, refusal to verify equipment, location monitoring discrepancies, and post-hearing contact with the victim. Together, these behaviors paint a picture of a defendant unwilling or unable to comply with basic conditions. When the defense acknowledges the violations but tries to soften the narrative, the tension becomes clear. Defense attorneys must advocate for their clients, but even they struggle when the evidence shows intentional misconduct. The tether cut alone is enough to raise alarms. Combining it with unauthorized contact elevates the situation into a threat assessment. Judges consider two major questions in bond decisions. Is the defendant a danger to the community? Can the defendant be trusted to return to court and follow orders? Here, both answers lean heavily toward no.
Any response?
What was that court date for Judge Perry, real quick? I need help.
Before.
Thank you, Your Honor. Your Honor, I'm going to leave that to the court. My client wants to focus more on the preliminary exam and deal with the case at hand, Judge.
He's waiving the hearing on the phone issue?
Yes, Your Honor.
All right. And the court will order that his phone privileges are revoked as they previously had. And so this bond will continue in all other aspects as revoked.
Thank you, Your Honor.
People versus Christopher Farner. What are we doing?
Your Honor, at this time, we wish to set them for exam.
Preliminary examination in person will be set June 4th, 2024, 9 a.m. before Judge Washington.
I have kind of two options to my request, please. One is I'm requesting that his original bond be ordered at $200,000 cash. And we can request this. That is the request that we made at the time we charged it, and my position is that his bond should have been set at based on the facts of this case. In the alternative, I'm asking that Your Honor revoke the defendant's bond and remand him today for his bond violations. So I'll start with the bond violations, perhaps. After the defendant was arrested and in custody, and after he was arrested, he made 86 attempted calls to the victim, and 23 of those calls were completed. I had the opportunity to download a PDF and send that to defense counsel, as well as download the 23 completed calls. I did also accidentally download some of the incompleted calls and sent those her way as well. But she's had access to them since yesterday, which is when I discovered them. I have not had the opportunity to listen to the content of all of the 23 completed calls. Of the calls that I was able to listen to, I was able to listen to the defendant talking to the victim about arranging his bond posted, arranging his pickup at a gas station near the jail, the two of them talking about how to get the no contact order dropped, about how they can have contact with each other once. So I'm requesting that his bond be revoked and that he not be permitted phone privileges in the jail for those violations. In regard to, and I should also note in terms of the jail phone calls, this is the defendant from Mr. Gates' case earlier when I mentioned that he had another defendant from the jail call and asked his victim for another phone call.
The other number?
Yes, this is Mr. Fickner is the person that participated in that, and he's the one that called her victim. Excuse me, Mr. Gates' victim. So in regard,
So he called the victim in the other case to get a new phone number so that that defendant could contact that victim.
correct. Thank you, Your Honor. In regard to the facts of this case, the defendant, and I'll kind of jump to the end and then go back through it. The defendant at the end of this admits to the police that he was intoxicated while driving the vehicle. While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast. And then when they got home, she watched as he was choking her mom.
This is one of the most disturbing portions of the entire hearing. The prosecutor lays out details that immediately elevate this case beyond a standard domestic violence allegation. Drunk driving with children in the car, threatening to crash the vehicle, physically assaulting the mother and strangling her while driving. These are behaviors courts classify as high lethality indicators. Strangulation alone is an enormous red flag, often associated with dramatically increased risk of fatal harm in future incidents. What makes this testimony even more compelling is the corroboration. The 8-year-old child's statement aligns with the victim's story, and both parents later confirming physical violence adds layers of credibility. Judges rely heavily on consistent witness accounts, especially when minors witness the event. Visible injuries like redness and a blood blister near the trachea only strengthen the case. Viewers, when multiple witnesses and physical evidence support a victim's account, should bond ever remain low, or should courts immediately assume risk and increase restrictions? Judge Simpson is clearly absorbing the severity of this situation, and the consequences he issues next show exactly how seriously courts treat cases like this.
The victim is that child's mom who reported to the police that in the car, the defendant decided to begin an argument with her, calling her a psychopath, saying to him that she could not take his guns away from him, that he hit her in the head while he was driving, and actually while he was still driving the vehicle began to strangle her. The victim reported separately from the interview with the child with the police reported that the defendant told her while he was driving the car that he was going to crash the car, kill them all, and that it would be her fault. He said that with children in the car, and that the 8-year-old subsequently cooperating that. As I mentioned earlier, he had consumed alcohol and he later admitted to the police that he was intoxicated at the time of driving that vehicle. In the vehicle, put both of his hands around the victim's neck and strangled her. She couldn't breathe. At a stop sign, the victim tried to get out of the car to flee, but the defendant sped off. Once they were home, inside the home, both of her parents were present and her parents were interviewed separately. The victim told the police that the defendant choked her and threw her to the ground. The victim's father, who was present, said that he walked in and he saw the defendant with the victim in a chokehold, that he said, "What the F," except he actually swore, "Are you doing?" And the defendant immediately released her, throwing her to the ground.
When third-party witnesses confirm violence, the case gains a level of credibility that courts cannot overlook. Here, both parents independently reported seeing the defendant choke the victim, one describing a chokehold severe enough to prompt an immediate confrontation. That kind of eyewitness account matters because it eliminates ambiguity. No one can argue misunderstandings, exaggerations, or misinterpretations when multiple adults see the same violent act. Judges also look at escalation patterns. The violence that began in a moving vehicle continued inside a home with other adults present. That shows boldness. Violence that persists even when witnesses are nearby signals a lack of impulse control and a disregard for consequences. The physical injury described, a blood blister near the trachea, is consistent with dangerous pressure applied to the neck. Strangulation injuries are among the most lethal forms of domestic assault because they can cause internal damage even when external marks appear minor. Everything here indicates elevated risk. Judge Simpson's eventual decision reflects exactly how courts respond when evidence points to ongoing, escalating danger.
The mom also was interviewed separately. She said that she saw the victim push the defendant and that the defendant then put his hand on the victim's throat and began pushing her by her neck, and that the mom then left the room and did not see what else happened. The police observed redness on the victim's neck, a V-shape, they put in the report as a blood blister near her trachea. And those are the injuries they observed of her. So just based on the facts alone of this case, I am reviewing my office's response to cash surveys that would have been the appropriate bond to set at the time. However, if your honor is inclined to, frankly, I'm asking that you just revoke bond completely, set him a bond, remand him for these jail calls and contact he's had with the victim after the agreement, and order that he not be permitted to use the phones in the jail. Thank you, Your Honor.
Response.
Thank you, Your Honor. Our ultimate request is to keep bond set as where it is. As to the allegations of this case, I will just point out they still are allegations. And upon review of discovery, my client does maintain that a lot of what is in the report is incorrect. As to the jail calls, that is correct. Ms. Hughes did.
A lot or all?
Well, some of the identifying information would be correct in the report, but the allegations that would be criminal, my client denies. As to the jail phone calls, that is correct. Ms. Hughes did provide me with both the log and a folder with the calls in them yesterday afternoon. I have had the opportunity to review the log. However, I have not reviewed the substance of the calls in their entirety. I would acknowledge that some of the calls were made to the complaint witness's number and arraignment. However, to my understanding, there are no allegations of any other bond violations, either contact or otherwise, since my client's release from the Washtenaw County Jail.
What about his participation to facilitate another individual violating their bond condition?
The first I'm hearing of that is today, Your Honor. So I can't speak as to that whatsoever. I am asking the court to keep the bond set as where it is. Mr. Fainer has been out for, I believe, how long have you been out since posting the bond?
Last week, Thursday.
Last week, Thursday. So exactly 1 week, Your Honor, to my understanding. And that week, he has not had contact with the complaining witness nor violated his bond in any other way. We are asking for it to stay as is so he continues showing up to court. And he has been very active in the defense for this case. He is a foreman for a construction company and does have full-time work providing for his 5 young children. We are asking the court to keep bond where it is at this time.
Well, I don't know why the bond was set on those facts. Is he on a tether?
Yes, Your Honor.
given the facts of this case, or at least as they're relayed to the court, I believe that the bond as set is an abuse of discretion. Everything that's mentioned is high lethality.
This is a rare moment of judicial candor. Judges almost never publicly criticize a prior bond decision, but here, Judge Simpson openly states that the original bond was too low given the high lethality indicators. That phrase, high lethality, is extremely significant. Courts use it for cases where patterns strongly suggest a risk of severe injury or death if the defendant remains free. Consider what the judge is reacting to: intoxicated driving with children, threats to kill the passengers, strangulation, assault witnessed by parents, post-arrest contact attempts, involvement in another inmate's bond violations. Each factor alone is concerning. Combined, they form a profile of someone courts consider dangerous and unpredictable. When a judge sees a pattern of physical violence, coercive control, and disregard for bond conditions, revoking bond becomes almost mandatory. Viewers, should judges always revisit prior bond decisions when new information emerges, or should initial rulings carry more weight even when flawed? Judge Simpson makes his position clear. Safety comes first, and past leniency won't override present danger.
The alleged victim in this case ended up at least going to the hospital to tend to wounds that she is alleging were caused by the defendant. Moreover, then, that after all of this occurs, and what causes the court a great concern as to the defendant's conduct is that there are these contacts that aren't supposed to be contacts while he's in the jail, that then also then while he's in the jail, and I don't have any reason to dispute it because I had to revoke that other individual's phone privileges, he facilitates, not only does he violate a condition of his bond, he then facilitates another inmate violate the bond in the case, or in the other case. Not going to happen. It's just simple. I think the bond initially was set wrong. His behavior since then would lead this court to believe that the defendant cannot conduct himself reasonably, would also then pose a danger not only to the community, but to this particular victim and to the community as a whole. Defendant's bond, and he hasn't complied with the bond as we've said it, Mr. Allen. Defendant's bond is hereby ordered revoked. His phone privileges are also ordered revoked. Defendant is remanded.
This ruling marks a firm turning point in the hearing. The judge revokes bond, revokes phone privileges, and remands the defendant without hesitation. This moment illustrates how the justice system responds when a defendant not only endangers others, but also demonstrates a willingness to manipulate the system from inside jail. What's notable here is the judge's certainty. He doesn't deliberate long because the facts leave little room for leniency. The defendant's behavior isn't just irresponsible, it shows active disregard for the court's authority. That alone can justify revocation. Think of bond as an agreement. The court gives temporary freedom. The defendant promises compliance. When the defendant breaks that agreement blatantly, especially in cases involving violence, the judge must reevaluate the risk immediately. Viewers, when a defendant abuses both freedom and restricted privileges, should the court ever consider reinstating bond later, or should revocation be permanent until trial? In this courtroom, Judge Simpson sets a clear message. Violations have consequences.
Court calls case People versus Victor Hayes.
Thanks, Your Honor. This is going to be a waiver and a bond violation.
Yeah, it may not be a waiver. He's blowing numbers. Why?
Oh, Your Honor, this was
Mr. Allen.
This was an honest mistake on behalf of Mr. Hayes. He had company over on May 8th. He blew a .033 on his Soberlink. He's been on a Soberlink since November. And when he was having dinner, the company that he had with him, his friends and family, they had non-alcoholic wine. And Mr. Hayes was unaware that non-alcoholic wine actually can contain some to little bits of alcohol. So Mr. Hayes just wants this court.
You're going to tell me you got to a .03 on non-alcoholic wine? Is that, no, I mean, if that's what you're telling me, go ahead. I just want to make sure I'm hearing what you're telling me.
Your Honor, I spoke with Mr. Hayes about this, and the only explanation to this violation was what I just stated for the non-alcoholic wine at dinner. And he wants this court to know that this was an honest mistake. He's understands that he needs to do his due diligence and make sure that he's not around any alcohol whatsoever. And he would just like you to know that, you know, he's sincerely apologetic, and he's asking this court if it would allow him just to give him a chance to remain out of custody, continue to test while he's doing.
Then tell me the truth.
Judge Simpson, can I address the court, please?
If you want.
I've been testing for a while, and this all started in 2022 when I took it upon myself to Sacred Heart. And I'm trying to get some closure to this. And I had company over, and we had what I assumed was a non-alcoholic wine.
Hold on. You assumed it to be, or it was?
I assumed it to be. So I take.
Well, hold it. There's a big difference. Huge difference.
Well, only what I can say is that she said, "Oh, this is non-alcoholic, so I'm not supposed to drink." She said, "Well, this is not non-alcohol." So when I got the call from Mr. Wells and he said that I have blue numbers, I was shocked. It really didn't taste like alcohol, but I take full responsibility. I apologize to the courts. I'm trying to do my best to comply with what the courts want me to do. I've been 0-0-0 quite some time.
When you test.
Yes, I see Mr. Allen is behind me, so I know what that means. So I mean, I got a lot of responsibility, and I apologize to the courts. I really do, and this will never happen again.
Well, somebody needs to tell me the truth about what it was, because if one counsel got up here and said you were having non-alcoholic wine, but it has some alcohol in it, that's different than it was non-alcoholic wine, or I thought it was, or I assumed it was.
I understand. Well, when I spoke with Mr. Simpson, Mr. Wells, Judge Simpson, he said, "Don't you know non-alcoholic wine contains some alcohol?" And I never knew that. So it's an
not to get you to these, how much of this wine did you have?
I had a couple glasses. And I mean, it didn't taste like alcohol, but I mean, I had a little buzz, but I didn't realize it was going to cause me to, Mr. Allen to be standing behind me. And
you got, don't you worry about what Mr. Allen's doing. You got.
I'm sorry, Judge.
Story doesn't add up.
I understand.
Because it's not off it. Why is he getting buzzed off of non-alcoholic wine? I mean, you know what you're doing at some point.
Yes.
Well, if he wants to waive, he'll do it next week.
Understood, Your Honor.
But at this point, defendant's bond is revoked, defendant's remanded.
It's Your Honor.
I get nervous when you're behind me too.
Here, the consequences become immediate. The judge revokes Hayes' bond and orders him remanded. What's striking is not the alcohol reading itself, but the defendant's inability to give a consistent, truthful account of what happened. Courts rely heavily on credibility. When a defendant's explanation collapses under scrutiny, judges assume they cannot be trusted with compliance. Another factor at play is the defendant's acknowledgement of a buzz. Even if he believed the wine was non-alcoholic, the sensation of intoxication should have been an immediate red flag. Instead of stopping, he continued drinking. That suggests poor judgment, which courts view as a predictor of future violations. This moment highlights a core courtroom principle. Integrity weighs as heavily as evidence. When defendants cannot take responsibility, even small violations snowball into major consequences. Hayes' bond is gone, not because of the number, but because of the narrative around it.
Case People versus Thomas Styron.
Public defender Ortella on behalf of Mr. Styron. Well, let's talk to the judge about that. Right? We've been through this.
What's the confusion?
I stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do be direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
This is one of the most dramatic behavioral clashes of the hearing. Styron is openly laughing, smirking, and challenging the court's authority. Behavior judges categorize as contemptuous and disruptive. In a courtroom, disrespect isn't just rude. It threatens the integrity of the proceedings. When a defendant shows blatant disregard, it becomes nearly impossible to conduct hearings efficiently or safely. Judge Simpson's reaction is swift. One more laugh equals 30 days. And when Styron continues defiance, the judge immediately follows through. This isn't punitive, it's protective. Without control, a courtroom spirals into chaos, especially when defendants are unpredictable or combative. Styron's behavior escalates further into pseudo-legal language, trust, entity, sovereign arguments, signaling a belief system often linked to sovereign citizen rhetoric. Courts treat this as a major red flag because it often leads to refusal to comply, refusal to recognize jurisdiction, and repeated disruptions. Viewers, should courts offer patience for individuals using pseudo-legal arguments or enforce strict consequences immediately to maintain order? Judge Simpson chooses order.
You may need an attorney. Your fault.
That's the Forensic Center. They also did not sign in, nor have they responded to email.
And Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin.
The Forensic Center did not sign in for whatever reason.
Your Honor, could we have Deputy Allen stand behind the people at the Forensic Center?
Get. I know. All right. I'll adjourn these out until the 13th.
All right, thank you. Ms. Allen, be ready.
Yeah, now you want to be friends. Huh? Court does call the case, People versus Shaqualin Turner.
Assistant Public Defender Jay Bellinger on behalf of Mr. Turner, who approaches. We would just be asking for 2 weeks in this matter. It looks like the matter is scheduled on the 5th. See if we can come to global resolution.
This case that you have today forms a case of bond violation for the domestic violence case. Judge Barr, at my request, revoked bonds until June 5th, the final settlement conference date of the pending domestic.
This courtroom session showcased nearly every challenge judges face. Uncooperative defendants, dangerous bond violations, emotional domestic cases, confusion over legal procedures, and open defiance of authority. Judge Simpson moved through each situation with a balance of firmness and clarity, revoking bond when necessary, enforcing consequences, protecting victims, and ensuring due process even when defendants resisted it. Key takeaways from this hearing. Bond is not a right. It is earned through compliance. Phone violations and victim contact are treated as serious threats. Domestic violence cases with strangulation or threats receive heightened scrutiny. Self-representation requires true understanding, not confidence alone. Contempt of court can change a defendant's future instantly. This video demonstrates how quickly courtroom dynamics shift based on behavior. Every defendant shapes their own outcome, sometimes for the better, often for the worse. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.